name is Bruce Roth. I'm a real estate broker here in Las Vegas, Nevada. And today as my guest, I have with me Jeremy Cooper of Cooper Coons, and he's a member of the Nevada Bar. So Jeremy, I wanted to ask you, that means he's a lawyer, just in case you didn't know. I want to ask you a question.
Okay.
Can you please tell us, do I need a trust in addition to a will? A lot of people know that they need to have their, so that their property goes to who they want.
Right.
If they need a trust in addition, why do they?
So, as an estate planner, we help people put their affairs in order in such a way to where they do not have to get the court involved in deciding who makes decisions for them or who gets what when they die, unless they want the court to be involved. And so the way we do that is through documents like a living trust, a last will and testament, powers of attorney for healthcare, powers of attorney for financial matters. By having these types of documents in place, individuals are able to say who they want to be in these different positions to make decisions for either them or for their assets or their finances if they are incapacitated or if they've passed away. Without these types of documents, we don't have any real guidance, anything legally binding at least from our clients, and so at that point we have to go to court. We have to either probate assets in order to transfer them to family members or loved ones, or we have to go to court to get a guardianship over an incapacitated person. And anytime we're dealing with the court, we're never sure if we're going to get the desired result that our clients would want, and we're spending a lot more time with spending the client's money or the estate's money and dealing with the court, and it just, the duration of these processes is longer than it needs to be if we, as opposed to if we just had these documents in place. So without a trust, if we just have a will, we're having to go through probate. Without powers of attorney, we're having to get guardianship. So those are the primary reasons why it makes sense to have a trust, a will, and powers of attorney in place.
For an average family, let's say they own one primary residence and maybe a rental house or a vacation property. They have maybe, let's say their net worth aside from their real estate was $1 million.
Mm-hmm.
Okay, not a rich family, not a poor family.
Right.
What would the difference in cost be for the family who did plan ahead and had a trust in place versus the family that didn't and had to probate everything?
That's a good question. So if you work with someone like us, and I think our prices are fairly competitive, and you put together a pretty comprehensive estate plan, meaning you put the trust, the will, the powers of attorney in place, you're spending anywhere from $2,000 to $2,500 to put those documents into place.
Pretty nominal.
Right, it's not really that much. If you don't do that, and we end up having to probate your assets, and you have $1 million estate, fees could get up to somewhere in the range. It depends, but they could range between $10,000 to $15,000, if not more. And it's not always the fees that are most bothersome, I guess, to our clients, or at least their heirs. It's the amount of time that a probate takes. It's not uncommon that a probate of that size would last well in excess of a year, which means those assets are locked up and not able to be distributed to beneficiaries until we complete the probate in most cases. So that's really what tends to bother clients more so than the fees themselves. The fees are paid from the estate, so sometimes they don't really care as much about that as long as they get their share in the end. It's just that they don't want to have to wait a year and a half to 2 years to get their inheritance.
You briefly mentioned something that was important with my family. When I handled my parents, my father died of dementia. Mm-hmm. And because he had the medical power of attorney and all that in place, I was able to move him from California to Nevada so I could supervise him more carefully. I was able to buy him new health insurance. He put me on all his bank accounts that he did before he went all the way downhill. But how would that process have been for me if I didn't have those powers in place?
So in a situation like that, you would have had to get a guardianship over him, over both his person to make healthcare decisions for him and over his estate in order to make financial decisions for him or asset management type decisions. And so that, again, is a process of where you're going to court, you're paying attorneys most likely to represent you, assuming none of your family members would have contested your petition to be his guardian, then it would have been smoother than
And they might have.
Yeah, they could have, and then that obviously creates more problems. In your case, you maybe circumvented some of those things where he put your name on some of the accounts. There was not necessarily a need for a guardianship over his estate. Maybe if you had access to all of his assets, that doesn't mean you could sign tax returns or deal with life insurance companies on his behalf without a guardianship, but it would help in at least being able to get to his funds. However, I don't always recommend that type of approach, because if you were an actual joint account holder with him, those assets become your assets as well.
And the tax liability could accrue to me.
Well, not only that, but if you ended up having any kind of issue with a creditor or with a lawsuit
they could
or
attach
a divorce, that those assets could suddenly be considered your assets for
Community
purposes
property.
of satisfying different types of issues like that. So with a trust, you are able to step in and act on his behalf without exposing his assets to your problems.
Great. Thank you so much. I appreciate it.
You're welcome.
Thank you.